Record should reflect that the individual known to this court as Darrell Brooks is present in person in custody in street clothing, wearing a suit and tie and a mask.
For the record,
today.
I do not consent to being called that name, Your Honor.
All right,
And we still have yet to address subject matter jurisdiction.
The court has addressed it for the record. So
for the record, has it been proven?
Mr. Brooks, I stand by the written decision that I issued in this case last week. A second copy was provided. Please don't interrupt me. A second copy was provided to you. I know you saw it because you tore it up yesterday. So I'm not going to address it any further. You are mistaken and wrong about the law that it needs to be verified or proven.
Are you talking about the paper I accepted in return for value?
So with that, I believe, Mr. Brooks, I'm going to continue with this trial, whether you believe jurisdiction has been proven or not.
It has not been proven for the record.
And it has. So with that, Detective Carpenter was on the stand.
And it needs to be proven.
And I
per the prosecution
would like to have him brought back up unless there's any other issues the parties wish the court to address from the state.
I did want to address something briefly.
Go ahead.
As the court knows from our short discussions yesterday, the state will be playing a couple videos of the defendants and his statements. The court had previously heard those as part of a motion hearing, and I'm not sure if I'm really giving the defendant notice or what I'm doing, but I really tried hard, and I'm pulling out snippets from this because if the court recalls, there are a lot of references that the defendant makes to prior domestics with Erica, his prior record, things that the court had previously excluded. So I'm going through and I am pulling specific time ranges from this so that nothing that was previously ruled inadmissible comes in. And I guess obviously this defendant has the absolute right to cross-examine the witness. He has the right, and we've offered and we have been putting exhibits up for him. But I do want it to be noted that I would not be willing to have Mr. Brooks just say, oh, go to about the 7-minute mark, because if he even goes like 2 seconds before a clip that I had played or 2 seconds after, it could include information that was previously ruled inadmissible. And I guess what I would say to the defendant is the court has previously protected the defendant to make sure that things didn't come out, where he asked a question that could be construed as opening the door, and the court said, we're not going to go there, Mr. Brooks, and he got the message. However, with this, if there's any portion of this video that's played that talks about the prior with Erica, I do consider that he has opened the door, and I will be asking the witness about it. So I guess this is maybe more so directed at Mr. Brooks, that if he plays clips that contain that information, he will have opened the door. He's had this video for weeks at least. These videos have been subject to a motion hearing. I'm not sure exactly what access he had to them before. I've reviewed the 5-hour video a number of times. I've been very meticulous in my timestamps that I'm grabbing out from here. And I am unwilling to have the defendant put Ms. Gussie in a spot where he's kind of, well, around this point. He needs to give exact times that he wants started and stopped, because what happens is if he says, okay, can you pause here? By the time he says that, 5 seconds may have gone by, which may be enough to, some of these, if I would play 2 more seconds than what I have here, it would open the door. So I just want the defendant to realize that this is kind of a slippery slope here, and he proceeds at his own risk. And I'm not going to ask Ms. Gussie to stop it at a certain time because I think something's about to be said. That's on the defendant. And if he opens the door, I can assure you, I will go into it. So I did want to put that on the record, Judge, not to be a jerk about it, but just once it's out there, I can't not address it. And if it's the defendant who brings it out there into the view of the jury, then I'm going to feel compelled to address it. And then I didn't know if the court wanted to go through the preliminary instruction that you had provided previously on the interpreter. My understanding is that Mr. Marquez speaks very little English. If you want to add the added paragraph, that would be fine for the state. I've had 2 discussions with him, and I would not say he is, that English is a comfortable language for him.
All right, thank you. As to the first part, to what the state brings up regarding the redacted recording, I would remind Mr. Brooks the court did enter some rulings previously. Why do you have to roll your eyes at me? Let's start the morning off on a good note,
I didn't
sir.
roll my eyes at you, so I don't think it's fair that you should say I rolled my eyes at you.
I saw you roll your eyes at me. I'm not
I
going to
didn't roll
debate
my
about
eyes
it.
at you, so don't do that.
Well, Mr. Brooks, I'd appreciate a little bit more respect. These
I would too,
rulings,
Your Honor.
let me finish, because now you're interrupting me. These rulings were entered by the court to prevent other acts evidence from coming in, but a defendant can open the door in a variety of ways. These recordings, and I have reviewed them previously, do contain discussion and statements by you regarding these other acts. And as you heard from Attorney Basie, she has all of the timestamps to stop at appropriate times so that the state does not run afoul of those pretrial rulings. You can open the door by asking questions, by asking for a video to be played, and not knowing those exact timestamps. I think it's important that I reinforce what the state has just advised you of, so that when you are watching the recording, as all of us will be, if there is something you want replayed and you want to cross-examine the witness about, that you know those time stamps, and then the state has graciously indicated they would assist once again in replaying portions of that video. I don't need a response from you unless you feel you would like to give a response to any of that.
With all due respect, they're the ones that want to play the video, so I don't understand how I'm the one opening the door. They chose to play the video, so.
They're not going to play the entire video, though. They're going to redact out, probably stop, fast forward, the portions that this court said would be inadmissible. So for example, if during your cross-examination of Detective Carpenter, you ask the state to replay a portion of the video and you say, go back to around the 7-minute mark, you have to understand that you may open the door, even inadvertently, to some of those other acts, evidence coming in. So what I'm telling you is, if you want any portions replayed, then, or if you ask for the entire video to be played under the rule of completeness, that you have an understanding that you would be opening the door to the evidence of other acts coming in. Potentially, I'll have to rule on it at that time. So be mindful of the timestamps.
I don't understand, and Your Honor, that's almost like you making a ruling and then it not having any standing. If you already made a ruling.
The ruling's against them. I told the state they can't offer this evidence.
Right,
They're
that's
the
what
one.
I'm saying.
So if you offer the evidence or ask questions that would open the door, that's a different story. And we all have treaded lightly when you've asked questions that would have opened the door to a variety of witnesses. So the state's just simply saying, look, we're going to do our job. We're not going to put in the other act's evidence. We're going to pause the video, fast forward the appropriate spots. But if you want any portions replayed, or if you ask for the entire video to be played, then you do that at your peril of having those other acts' evidence come in. So that's all I want to tell you. As far as the jury instruction, do you have any position on whether that second well, I shouldn't say second, it's the very last paragraph where it says, add the following if appropriate. Do you have any position on whether the court reads this entire jury instruction 60 to the jury prior to Mr. Marquez being called as a witness?
Yeah, I think the jury should hear whatever needs that they need to hear.
Do you have a position on that last paragraph specifically, sir, given the information that the state has provided today?
Last paragraph.
It's in brackets and it's after a bolded section that says, add the following if appropriate. I advised the parties yesterday we would be talking about that this morning.
I mean, it was just stated that the witness doesn't speak very good English. And so that would indicate that it would be a lot more work for the interpreter to make sure.
That's not what I'm asking about, sir. I'm asking whether you have a position on whether I include the very last paragraph of that instruction to the jury.
No, I don't feel like that needs to be read to the jury. I think it's pretty clear from all the language leading up to that.
Let me ask Attorney Basie a question about the contact the Office of the District Attorney has had with Mr. Marquez. Were you able to communicate at all in any way in English, even if you would describe it as broken English?
Yes, I think our last conversation, we probably said, I said something in English, he responded, and then when I said something else, I think he needed translation for that. His primary, our victim witness person, specialist assigned to the case, is bilingual, and she speaks to him in Spanish.
All right, given that bit of information provided by the DAs and Office of the Court regarding his ability to answer some but not most, I think it's appropriate to read the very last paragraph. Certainly doesn't hurt. It's not going to take away. So I will read the entirety of jury instruction 60. Obviously the part that says read here if appropriate comes out, and then I will print that off, and that is what I will read at the appropriate time. Did that print, Madam Clerk?
Quick question on that. How do we know exactly what words the witness will be able to understand in English versus?
That's not how the interpretation works. The questions are in English, they're interpreted in Spanish to the witness. The witness will answer, presumably in Spanish, and then the witness's words will be interpreted in English, and it's the English, as this instruction says, that is the evidence.
I think it's a little unfair that prosecution has had conversations with the witness and I haven't, considering that it's my witness.
They were on the state's witness list as well, I believe. So it's fair for either party to reach out, and if witnesses want to talk to either party in preparation, that's frankly fair game.
So how would I be able to reach out to a witness?
Mr. Brooks, you are representing yourself. That obviously poses some challenges and difficulties, but that is the state and stage that we are at. So with that, I know we'll get Detective Carpenter on the stand. He can come up and be out here when the jury comes out. So come on up, sir. I will swear you in again, as is my practice when there's a witness on the stand for a second day.
I have one more thing real quick.
Well, it needs to be other than subject matter jurisdiction, so what is it?
You didn't even let me get to it.
I said, what is it? I said it needs to be something other than subject matter jurisdiction.
Can I
What
get
is
to it?
You can say.
There's no way to know what I'm going to say if I can't say it.
Mr. Brooks, please tell me what it is you'd like to address.
I want to address why my ICFs have not been addressed, because I know you have them. Why have I not getting copies? I've gotten copies of every other ICF. Why not the recent ones?
Sir, I am not going to be the intermediary anymore for ICFs that are directed to the clerk of court regarding copies.
That's not explaining why I haven't.
I'm not
even
the
been
keeper
told
of the
if
record, so
they've
if there's
been
something
received.
you want me to address, then you should address your ICF to me and not the clerk of court.
Well, where is the ICF?
Sir,
if I sent it, I should be able to get a copy. I've gotten copies of every single one.
You need
whether
to
they were
ask
addressed,
for that from the clerk of
whether
court.
they were addressed to you or whether they were addressed to the clerk of courts. I've always
I'm not going to
been
address
told.
that further, Mr. Brooks. I'm not going to be the intermediary when
So
you
what's
have
the-
questions to the clerk of court.
So
for
what's the
copies
point
and
of me
things like
sending the
that.
ICF, me doing what you asked me to do, and sending them, and then not being able to know if they've even been received and get a copy of them, which I've been getting copies of
If you
them
did not
ever
ask
since.
for a copy of the ICF, they don't have any obligation to send
I
it
addressed
back to you.
it when I first sent it. I asked you on the record, did you receive it?
Mr. Brooks,
You
I
said-
didn't receive anything because nothing has been sent to me.
Well,
So
where's the
if there's
ICF?
something that you need, then you should reach back out to the clerk of court.
I shouldn't have to do
But
that
we're
if
not
I
going to
sent
take
it.
up court time regarding an ICF sent to the clerk of court. Again, I will advise you once again, I did this the other day, if there's something case related, it needs to be addressed to me. If it has to do with the record, it needs to go to the clerk of court.
And it was.
Because
It
I
was
am
sent to the
not
clerk of court.
the
But I still should be.
custodian.
I still should be able to be told if it was received and get a copy, which you've done that before. Every single ICF.
And I told you I
So why
would
does
no
it change?
longer be doing that, sir, because of this very issue. It
So you
takes
saying
up
so
court
now it
time.
changes? So now it changes all of a sudden?
No, it didn't change all of a sudden, sir, and you know that, so don't
No,
try to
no.
confuse
Does
the
it
record.
change all of a suddenly? Because
No,
I've been getting copies of everything I've sent, which is what you asked me to
This
do.
changed last week, and you
It
know
should.
that.
It shouldn't change.
So
no, I
with
don't
that,
know it.
I'm bringing the jury out, and I'm not addressing this issue,
So
sir.
I
We're
want the
gonna
copy of
continue
my
forward.
ICFs that I send.
Send the request to the
I don't
clerk's
have to send her
office.
another request. Where's the one that I just sent last week?
All right, the jury is going to come out, so please be respectful.
I will, but at the same time, you still have to. I did what you asked me to do. If you tell me to do something and I do it, and then now you're saying I'm not gonna get a copy, which you've been providing them ever since you told me to do it.
Mr. Brooks, the rules on that changed last week.
No,
You know
it
that.
did not. I'm still supposed to be able to say if it's been received or not. So why should I have to send multiple ICFs to even know if they've been received? That's ridiculous, Your
I'm
Honor.
going to give the parties the final version of jury instruction 60, which I will be reading at the
That's-
appropriate time.
Come on, you can't change stuff at the last minute. You
No,
asked me
Mr.
to do
Brooks, I
something.
did it as a courtesy,
You
and
act-
frankly,
no.
you're not courteous
I'm not.
to me.
I'm not
So
even.
the
I'm
jury's
not even.
coming out.
I'm not even
The
referring
record
to
should
that.
reflect that the jury
I'm referring
is
to the
coming
fact. I'm
out.
referring to the fact that you haven't even
Mr.
had enough
Brooks,
respect to tell
please
me
be
it's been
respectful
received.
to the jury. They're coming out.
Okay, that doesn't mean that you shouldn't be able to tell me if my ICF has been received. ICFs that you told me to submit. You told me that.
Ladies and gentlemen of the jury, you will disregard the commentary by Mr.
I
Brooks
accept
at
for
this
value in
point.
return for value this document. Just like you've been hiding everything from the jury that they
The
need to
jury
use.
will disregard. The court is not hiding anything from the
Yeah,
jury.
yeah, you are.
So,
Yeah, you
Mr.
are.
Brooks, please be respectful of the jury. They're
And you
coming
should,
out.
you should be respectful
We
of
are,
what you asked
you are
me to
addressing
do.
issues that are not related to evidence
They
in
are.
this case.
You asked me to do
Mr.
something, I
Brooks,
do it,
please.
and
All
then
right.
now it changes.
Everyone can be seated. Thank you.
This is ridiculous. Just like subject matter jurisdiction hasn't been proved. Just like you're making judicial determinations that you don't have to prove
on.
anything by law,
Hold on.
which is a tacit agreement by you, Your Honor.
Ladies and gentlemen of the jury, please disregard the statements currently
Why? 'Cause
being
it's
made
true?
by Mr. Brooks.
Why?
They
'Cause
are
it's true?
Incorrect statements of the law. They
Then
are
prove
not
that they're
evidence
incorrect. Prove.
in this case.
Where's the proof? Where's the legal proof?
And you need to disregard them.
Because you don't have it.
And we are
don't
going to
have legal
continue
proof.
with testimony, Mr. Brooks. I warn
I
you,
don't-
do
I don't-
not interrupt.
I
or
don't
we
identify by
will
that
have a
name.
discussion about whether you will continue to be here.
I don't
All right.
consent to being called that name for the record.
Detective Carpenter, please stand, as is my practice when a witness is on the stand for a second day to be sworn in again. Go ahead, Teresa. Please raise your right
Lie
hand.
to the jury.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. And just for the record, please state your name for day 2.